Yes, sir, I'm here.
Yeah, and who is Combs Burn? What's?
I have a case that's later to be called.
Pardon?
I have a case that's called later.
I can't hear you, man.
I'm sorry, I might have my microphone. I have a case that's called later.
Okay, turn your camera off then, okay? Thank you. Okay. And do you have an attorney with you, sir?
Yes, I'm here, Your Honor.
There you are. And your client's on
Zoom, Your Honor. Debbie Cole.
Okay, what, you have a motion here on the Vanguard account. I read it last night.
Yes, Your Honor, and I don't believe the respondent has any objections to it.
Okay, well, we'll enter that order then.
Actually, Your Honor, Ms. Bowen filed a proposed order earlier today. I don't know if it's in the record or not, but we've gone over it. It covers that account and several others, and we basically have no opposition to paragraphs 1, 5, 6, 7, and 5, 6, or 7 of that order. And the only three remaining are paragraphs 2, 3, and 4, and all those pertain to Foxfire and the tracing issue that we addressed last time.
Okay, well, let's take the Foxfire issue out, the tracing issue out, and submit an order on the agreed portions of it, and at least we made some progress, okay?
Absolutely, yeah. I can remove so we're keeping then 5, 6, and 7. Is that what you said, George?
No, 1,
1.
paragraph 1, paragraph 5, paragraph 6, paragraph 7.
Okay, I can retender, Your Honor. Another.
Now, what are we gonna do about the Foxfire and other issues here?
Your Honor, that's before the court now. We've tendered an order on that. I prepared the first order after the hearing. I prepared a transcript to try to closely.
Tell me what you need to do for me.
Well, we have tendered a proposed order that says that you ordered that after the sale of Arden Lane, the proceeds were divided 50-50, and those would be the separate property of the parties. Okay. And Ms. Bowen contends that allows her Foxfire tracing claim to stay alive. But I think it's completely inconsistent and said so at the hearing and repeating it now.
And then once we resolve that issue, what, is that it? Is there something else besides that?
That should be it.
Tell me about your Foxfire tracing situation, Counselor.
Your Honor, it's our position that we can trace it through the documentation that I provided to the court. I think it was at our last hearing that has been provided to Mr. Bertram, in addition to the testimony of my client. And Mr. Bertram, yes, he did issue his version of the agreed order based off of his interpretation of the transcript, but it's my position that the way he worded it is as if his motion for summary judgment was
Wait a second, it's been sold yet?
Foxfire burned 20 years ago.
Well, that's the
And
insurance proceeds.
she's trying to trace the Foxfire proceeds through various things.
Insurance proceeds.
Insurance,
Proceeds.
right. And through Arden Lane, all the money, she said, went in Arden Lane, and then it came out of Arden Lane and went into his house. And I'm saying, if it went into Arden Lane, that's the end of the tracing there, because you just divided it 50-50. It can't be separate property and non-marital property.
Can you prove that any of the insurance proceeds went anywhere but into that other house?
I mean, it went from into Arden Lane and then into his current house.
There's no documentation that any of it went into Arden Lane, but that's what they claimed, was that the insurance.
Well, I know, but if you're selling Arden Lane, right, and you're dividing it, that extinguishes that issue. My question is a simpler issue. The question that is, if you accept for a fact that it did go into Arden Lane, all of it, Counselor, what you would have to prove is that it went somewhere else other than Arden Lane. Can you prove that it went somewhere else other than Arden Lane? And if you can, we'll have a hearing, but I'm not going to trace all this. Are you saying that you are entitled to more than 50% of Arden Lane?
I don't know if I'm necessarily following what you mean.
I need to necessarily know what you're claiming so I can define the issues that we're going to have a hearing on, okay?
Yes, I believe my client is entitled to more than 50% because of his premarital claim from the original one and the increase.
Wait. Okay. But previously I ordered to sell 50-50.
Exactly. And said it was separate property. Each party within have to trace their half into current assets from that time that they got their half to now. And that's what we've done since the last hearing. We hired a CPA, we've traced our half of the money all the way into current assets. It's been a lot of time and effort doing it.
Okay, if this Art Lane was sold and the money, I mean, and it's still in existence, right?
No, Arden Lane was sold
It's been sold, Your Honor.
10 years ago.
Okay, so where's the money? Did they divide the
They
money?
divided it 50-50,
That's what you're, then,
and he got half of it and she got half of it.
so what's
Check.
the issue now then? If they've already separated that, what is the issue?
The issue is that Ms. Kohler is in possession of more money than she's entitled to through the Fidelity account. So their claim is that they put the money from the sale of Arden Lane into Fidelity, the joint Fidelity account, and then she removed that money, exactly that money. It is our position that she removed more than what she was entitled to.
How much more?
At least $100,000 more.
The only real issue here is just the tracing efforts. If they say all of our money from Foxfire went into Arden Lane, and you say Arden Lane was sold and divided 50-50, became separate property. If that's the end of the Fox tracing, and that will resolve.
As far as Arden Lane is concerned, that's the reason I asked you, if she could show any money went anywhere else but that.
And we've asked that as well. We've never.
Okay, what's your answer to that?
The money from Arden Lane going somewhere else, was that your question?
No, we know where the money from Arden Lane went. It went 50-50 after it was sold. I'm saying, do you trace anything else into any other asset other than Arden Lane that you think was marital property?
From
Yes, the respondent's Fidelity account and her other bank accounts. I also believe money went into the Raymond James account. She has a Raymond James that she purchased, I think within a couple of months after they received the insurance proceeds.
Well, I mean, it seems like you're double counting money there. If you claim, I mean, if they can prove that the money went into Arden Lane with those insurance proceeds, right?
Mhm.
If they can prove where all that went, then it doesn't matter what else she had anywhere else unless you say that she's hiding funds from them.
But nobody can prove where the Foxfire insurance proceeds went to, other than the party's general recollection. Part of it was used to go into Arden Lane, but what, how, and how much, nobody knows. There's no documentation on either side.
Well, then what we need to do, if you can't reach an agreement on this, is have a trial. I have a hearing on it.
Yes, Your Honor, happy to have one. That's exactly.
I'm glad you're happy to have one. I'm not too thrilled about it. I'm not too thrilled about it because I think that you're chasing rainbows here. And I think that, I don't see, but I will tell you that I'm not above sanctioning somebody if they use a day or two of my life and all these
Yes.
legal expenses to try to get some kind of leverage where they don't have any proof. You understand what I'm saying?
Yes, Your Honor.
Okay, get your calendar out.
Judge, if I could add one more thing, might be helpful here.
I don't think it would be helpful, but you can add it. Go ahead. I won't hear it, so.
Okay. We have spent a considerable amount of time and money tracing from Arden Lane into current assets, okay? And if we're going to have a hearing on this, I would ask the court use what's called a KR, and you may be familiar with a KRE 1006 exhibit, which is a cumulative exhibit, and make the parties provide tracing exhibits that you don't have to go through all this paperwork. You can do a 1006
That'd
procedure.
be lovely.
Yeah.
Can
I'm
you-
not familiar with that, Your Honor. What is it called?
That's KRE 1006
A
cumulative
KR
exhibit.
Say it one more time. KRE 1006.
KRE 1006.
Okay, what I want to do is y'all communicate outside the courtroom about this document, see if you can agree to use the document. It might make it more clear to your attorneys. But the attorneys and the clients, when they look at that, it might help them have a clear view of it without seeing the stack of papers that you say.
It would be.
And I will allow y'all to contact our office if you agree to use that thing, if a hearing is necessary. If not, be back here on June 25th and we'll set a date.
June the 25th. All right. Thank you, Your Honor.
Yeah, thank you.
Thank you.
Page versus Page. Okay, what do we have here?
Judge, I filed a motion asking if we could set this for a final hearing. We've gotten kind of stagnant since the last time we were here. We've not had any.
I've
movement.
never considered you to be stagnant.
I appreciate that. The case itself, however, is a different
It's
story.
probably not an opportune time to bring up non-marital tracing, given the last hearing I just sat through.
Well, if there's a program that does it all, maybe we can all just start.
The complications in this case is that Mr. Page had significant premarital assets, many of which were involved in some 1031 exchanges through Mr. Richardson's office in Glasgow. So I told Ms. Coleman, her motion is well received by me. I understand this case needs to move forward and get resolved. We did try mediation. It was a bit premature. We've received much more information about these transactions from Mr. Richardson's office. I'll admit to the court at this stage, I don't really want to bring Mr. Richardson in for a deposition, but I think we're going to have to talk to him to help understand these transactions better.
Bobby Richardson,
Correct. So again, I'm not objecting to her motion.
come up with an amount of money that you want.
Well, we had asked if they would make an offer. My understanding was maybe there was one made before I got in the case, and I had asked if maybe we
You
could
can
have an
slow down, you're
offer.
talking a little faster.
Because he's the one claiming a
Move
non-marital
over behind the
interest.
microphone. You're talking faster than I can hear. I
Sorry.
can't hear you. Move over behind the microphone. Okay. Have you come up with a number?
No,
Well, you can't settle a case if you don't come up with a number.
I feel like the burden is on them to
I'm
come up
not
with a
talking about a
number
burden.
because
I'm talking about moving on. If you don't want to give a number, you don't have to. But if there's a number that your client would be satisfied with, I would think it would be good to at least offer them so they know whether they'd rather go ahead and pay it out or litigate.
and I can do that, Judge.
Well, that'd
I
be
think
good.
that the concern is that they're claiming a non-marital interest in certain properties.
Is there a certain property your client wants to keep?
Not necessarily, she just wants to be bought out.
Well,
She
so
just wants
what
what
difference
she's
does it
entitled
make?
to. They're claiming it's not, that they're claiming a non-marital
Well, let's
interest.
forget what they're claiming.
I'm just saying, I think the burden's on them
I'm not talking about a
to
burden.
prove that.
Well, we'll get into hearings and burdens. I'm talking about a settlement. The best way to settle things is come up with an amount of money that you're willing to take and let them do their own calculation. If not, we'll law it out and let them lay where Jesus flings them, as my old law professor says, you know?
The challenge with that is that most of the information lies with Mr. Page that we still have not been given access to. So I don't think we're in a position for me to be able to make an offer that would be
How long
fair.
were these folks married?
Look at me. 9 years, Judge.
9 years.
Been separated.
2017.
How long have you been separated?
I think it's close to 2
Year and a half, I want to
year
say,
and a
yeah.
half. I
So we
think
got-
that's probably right.
So we got 7 years that we're talking about essentially. Well,
They acquired a fair amount of, I guess they built a house.
well, on each one of those pieces of property, then you'll have to trace the source
Yes,
or
sir.
purchase price on those. That shouldn't be too hard to do. Because if he didn't, if he didn't borrow money by these, the money came from somewhere. If he borrowed it and they paid a certain amount of it down at marital assets and it's left, there's an offset, right? I don't know. I don't know. It's not my fault. Maybe it is my fault that we haven't made any progress. Maybe I should have been pushing harder on the thing, but it doesn't seem like this ought to be too terribly hard. What ballpark figures do you think we're talking about? Are we talking about $300,000?
There's not that much marital activity.
Well,
There's
you
not.
know,
The vast,
100,000?
yeah, the vast majority and I understand what Ms. Coleman's saying. And I'll say, what we have provided much. We haven't provided all because we don't have it. That's what I'm telling the court. But these transactions occurred through these 1031 exchanges. There were multiple sources that were, for lack of a better term, escrowed for time being. And then so there are multiple transactions. It's not as easy to show that there was one home that was sold and one checking account, and that account then bought the second property.
How many pieces of property you talking?
There were multiple. I think there were 4 premarital assets that Mr.
How many
Payne owned.
acquisitions during the marriage?
I think 2.
There were more than that. They bought and sold quite a bit of property.
I'm not getting
Yeah,
into
it
the
was.
boat or the cars. I'm talking about the real estate.
I'm talking real estate too.
Yeah.
During the course of the marriage, there were several real estate transactions. And we were just asking if they're claiming that's non-marital, we need the documentation showing it came from the account that was a non-marital account. Because if it did not, then the argument there becomes it is marital. I mean, the presumption is it's marital, and I think the onus is on them to show that it's not.
You need to come up with amount of money. You need to talk to your client. You're familiar with what they got. If you know the other transactions, come up with amount of money. If not, have you heard of this tracer thing that they're using here?
I'm not familiar with that, Your Honor. That's
Be
news
pretty
to me.
interesting. Be pretty interesting. Of course, I'm on the cutting edge of technology
It
myself.
could be useful to the point of making Ms. Coleman obsolete at some point. Just you, I don't know. So I'm a little leery of technology.
I just don't want, I'll say as much time as you want, okay? I just don't want to be knocking around, counting spoons. I don't want to be counting spoons. You're bound to have some idea of how much money's involved here. And is there any other information you'd like from counsel that would help you determine an amount?
I think we've requested what we felt like we needed. It's just, I think he's not been able to get all
What
of
kind
that
of
from
things have you
time.
requested? What are
I
they?
would have to go back to my interrogatories, Judge, and review it. But just bank accounts, including the one that he's claiming was a non-marital, so that we can see when these transactions occurred, where did the money go when they received the
Yeah,
money
I
to
think
sell
that's
the
part
property?
of that's part of the miscommunication here. I don't think what I've conveyed adequately at this point. Most of these transactions occurred through Mr. Richardson's accounts, not Mr. Page's. And so that's why showing Mr. Page's account doesn't help much. Who's gonna have to explain this is gonna be Mr. Richardson through his accounts.
And there were 3 of those.
There were multiple transactions that flowed through Mr. Richardson. And these are premarital. And of all the non-marital types, this is the easiest for us. It should be because they were owned before they ever got married. There was, as I recall, I think a chicken farm, if I'm not mistaken. And then there was a farm that was held with other members of the Page family that he had a percentage of. And those monies eventually wound up in their holdings today, or at least substantial part of their holdings today. So I know Your Honor, I know this court well enough. When we ask for trial dates from Your Honor, sometimes you'll give me trial dates next week. This case can't be tried next week. If Ms. Coleman wants a trial date, I'm not bucking up against her, but I think that needs to probably be August, so that the court does have this ready in a format to do it.
I'll be glad to set, y'all talk to each other and see what kind of additional discovery you don't have or not, and bring something with specificity, not, we didn't get everything we wanted, or I gave them everything I had. I want some specificity in an order as far as any other exchange. You give me that, then we'll find out whether that's can get or not, and we'll set a trial date. We do it August, whatever, it doesn't matter. This got bifurcated, didn't it, some time ago?
Did quite some time ago, Judge.
Yeah.
And since then, it's just been stagnant. Like I said, my motion really was intended to get us at least in a room together, so we could hopefully figure out what direction we need to go to get some resolution.
I think we had a mediation since then.
Mm-mm.
The
Mediation was
before the
before that.
bifurcation?
Yes, it was before.
Thank you.
Time flies when you're having a good time.
Right.
It does, Your Honor.
Okay, thank y'all very much.
Thank you, Judge. Have a good afternoon.
You too, thank you. Epling versus Samuel Lee Anders. Okay, you're here for Mr. Anders
Yes, Judge.
and you're Mr. Epling. You have a motion here?
Yes, Judge, I'm here on a motion for summary judgment.
Okay, go ahead.
We're stating that there's no genuine issue of material fact due to the fact that Mr. Epling had a contract presented to him where he waived any type of right to inspection, any type of electrical inspection, anything that he is claiming. The interrogatories that he sent were outside of the scope, according to.
What kind of interrogatories? Did you file the interrogatories? I didn't see them.
I did not, Judge. These interrogatories were borderline harassment and had absolutely nothing
Well,
to do
give
with
me,
the case.
give me an idea of what he was asking for.
So interrogatory number 2, he's requesting for federal tax returns. Interrogatory number 5, he's requesting personal information regarding a trust that Mr. Anders may or may not be a part of.
Yeah.
Interrogatory number 6, he continues about the trust. This has zero to do about the property in
Why,
question.
why are you filing interrogatories about those unrelated issues?
I found out that he had filed a large sum of money to a trust in.
What does that have to do with this case?
Nothing really.
Okay, well, that answers that question. Nothing. Okay, so we'll strike those interrogatories. I've
There were
read
2 sets, Your Honor.
What's the other interrogatory?
Judge, I have one set of interrogatories and it lists, let's see, 8 interrogatories with multiple parts of each interrogatory. And they all are related to either this trust, a federal tax return, and then there is 2, I think, that list, wanting to know about a conversation that Mr. Anders may or may not have had with a city of Burkesville employee. But again,
That
Mr.
was an affidavit.
Mr. Epling waived any right to inspection, and then he also turned around and let Southern Nest Realty out of the litigation. He signed an agreed order with
They
them.
they have this listed. Southern Nest, they have it listed.
Yes,
Why
yes,
did you let them out?
because I'm not out for a big win some, I just want my electricity fixed.
Well, the problem is if you had some problem with the representation, usually insurance agents are involved in that. And insurance agents will want to look at that, and the only people who have insurance in these sort of places are real estate agents or that sort of thing, who see if there was any misrepresentation made to you or not. I've been very patient with allowing you to file all these motions and everything, and quite frankly, I don't think any of them hit the mark. I think that you have severe buyer's remorse, that you didn't have the place inspected before you bought it. You signed a document where you bought it as is, and you got a bad deal. The good thing about it is it's not that much money compared to the bad deals that you could have been, but you paid a tuition for the money you paid for this, and there's bound to be some value in the property that you can recover. So I'm entering a summary judgment for the defendant in the case because I don't think you've proven anything, and it'll be a
I
final.
don't think
It'll be final and appealable, and you can file an appeal. Okay, thank you very much.
Thank you, Judge.
Car tax lien portfolio versus Dale